In the reconstituted service agreement, the fascinating thing that occurs is that the chronology of the actual events, I mean, real life events, is the opposite of what appears. So here's what happened. The first thing they do is create the special purpose vehicle.
Yeah.
Second thing they do is issue certificates. The third thing they do is get the certificates rated. The fourth thing they do is they either purchase insurance or credit default swaps. The fifth thing they do is they sell the certificates to the investor. The next thing they do is collect the money, aggregate the money from the investors. The money goes to an aggregator, and that aggregator then puts the demand downline on the securitization chain to mortgage originators and brokers. It says, I need $100 million in loans. And I need, and here are the terms of the loans in categories, because they've already created tranches in the SPV. Remember, first thing they did was they created the special purpose vehicle. So without any loans, they have tranche A, tranche B, tranche C, tranche D, tranche Z, toxic waste. It's already there. And whether they use the Lehman approach, which was they actually attach a spreadsheet, which they refer to in the documents as being populated by sample data, which is to say false. All right. But it will be replaced later with real loans. They then have this demand that they've made on the mortgage brokers and loan originators, which eventually got to the point where they couldn't satisfy the demand. So the aggregator created companies that would originate loans. And that's why you got B and C for Lehman and all this other stuff. B and C, it was owned by Aurora, which was owned by Lehman, et cetera. Okay. So now the money is still with the aggregator. Okay. Now they sign a pooling and service agreement and an assignment and assumption agreement. And then they get their first loan application. And all the rest of the loan applications. And then the aggregator funds the loans because he's holding the money from the investors. And they send various reports which are of dubious accuracy, populating the data for that special purpose vehicle, which they change around at will, using either MERS, because they have the right to go in there on their password and change any data they want. Or using their own internal devices, which Lehman, Bear Stearns, Citi, and others also did. So you had MERS and you had a shadow MERS. So whether you have MERS or not, you still have MERS, the effect of MERS. So they're constantly changing around the data and all that stuff. The reason why you have in these foreclosures the appearance of all these other companies out of nowhere, trustee services, foreclosure reconstruct services, and all this other stuff, is that they need to funnel them to make sure that it rarely happens that the same property and the same borrower is foreclosed upon at the same time by more than one supposed lender. They don't know who owns the loans, and they don't care. All they care about is making sure that two people don't make a claim on the same property at the same time. So in order to do that, they had to create these companies that were outsourced providers of foreclosure services. Well, back before securitization, that was called lawyers. No longer. Because in order to make this happen, they had to fabricate the documents necessary to show that Wells Fargo is the owner of this loan and nobody else. When in fact, as we've just described, way before Wells Fargo ever entered the picture, the security was sold to the investor, thereby locking in all rights under the assignment and assumption agreement and pooling and service agreement before your loan ever took place. So by operation of law, because those things already existed and money had changed hands, by operation of law, when you signed the papers for your loan, you were signing with the investor, but you didn't know it. But by operation of law, you were. So that's a roundabout way of getting to the point. Why did I say it was interesting in the reconstituted master pooling and service agreement? And the answer is, you can't execute another document after the sale to the investor. Every other document that is in place is fixed. Nobody has authority to change them without going to the investors, but nobody went to the investors. First of all, if anybody had gone to the investors might have peeked under the hood and said, "What are you doing under there?" Okay? So you see, not all the time, but in your case, you see a reconstituted agreement whereby the trustee is now making payments to Wells Fargo instead of payments going to the investors. But that's okay because the trustee didn't have the authority to do it anyway, so he's not doing anything. But Wells Fargo comes in and says, "We're Wells Fargo." You've heard that name, Judge. We've been around for 150 years. And it's inconceivable to the judge, although more and more judges are starting to see it, but it's inconceivable to most people that Wells Fargo would be so down and dirty as to be lying directly about what their position is in there. But I was in court in Reno, Nevada, where Wells Fargo attorney stood up and said, "We are the holder of the note." And in the afternoon said, "Excuse me, I misstated. We are only the servicer." At which point I gave the lawyer an elbow and I said, "That means we don't have a holder in this courtroom. We don't even have somebody claiming to be a holder. Seems to me all these foreclosures should be knocked out right now until they come up with one."